It's 11:45 on a Wednesday night. You're driving home on Route 9 outside Newark, New Jersey. Blue lights behind you. You pull over. The officer walks up, flashlight in your face, asks for license and registration. Then he says something you didn't expect. "Hand me your phone." No warrant, no explanation. Just a hand reaching through your window. And in that moment, you realize something that should terrify you. You have absolutely no idea whether you have to. 462 words. That's the entire Bill of Rights. The document that stands between you and the full power of the United States government. A government with 2.1 million civilian employees, 800 military bases in 70 countries, and the largest nuclear arsenal on the planet, fits on a single page. Written 235 years ago by men who didn't have running water. But here's the thing, nobody tells you. The Bill of Rights doesn't give you rights. Not a single one. It does something much stranger than that. It tells the most powerful government in human history what it can't do to you. That's not the same thing. And the difference matters more than you think. Every time you post something online, every time a cop knocks on your door, every time someone in a suit tells you, you can't do that. These 10 sentences are running in the background of your life like an operating system you never installed and never read the manual for. And they're the only thing standing between you and someone with a badge, a gun, and a very different idea of what you're allowed to do. So here's what we're going to do. I'm going to walk you through all 10 amendments in about 20 minutes, not in order. That'd be boring. Instead, I'm going to group them by what they actually protect. Your voice, your space, your defense, your fairness. And then the two that tie it all together, the ones almost nobody talks about, which might be the most important ones of all. Each group has a moment that'll make you stop and go, wait, that's how it works. I had at least 3 of those moments myself when I started studying this. Fair warning, once you see the pattern, you can't unsee it. Let's start with the one everybody thinks they understand. The First Amendment, 5 freedoms in one sentence. Religion, speech, press, assembly, and the right to petition the government. Most people only remember one of those, speech, and most people get it wrong. Here's what I mean. Sophia, 22, college senior in Boston. She posts a meme on Instagram making fun of her state's governor. Savage meme. The kind that gets screenshot and shared 40,000 times. Instagram removes it the next day. Sophia is furious. She tweets, "This is censorship. First Amendment. Look it up." And here's the thing. She's wrong. Not about the meme being funny. About the law. The First Amendment says, Congress shall make no law abridging the freedom of speech. Congress. The government. Not Instagram. Not your employer. Not your university's honor code committee. The government. When Instagram deletes your post, that's a private company enforcing its terms of service. You might hate it. You might think it's unfair. But it's not a First Amendment violation. The First Amendment only kicks in when the government tries to silence you. A senator can't throw you in jail for criticizing a policy. The FBI can't show up at your door because you wrote an op-ed. That's what the First Amendment protects. And that is genuinely powerful. But it doesn't mean what 90% of people on the internet think it means. That's wild when you think about it. The most famous protection in American law, the one people invoke more than any other, and most people fundamentally misunderstand who it protects them from. Now let's move into your space. This is where it gets personal. Literally. The Second Amendment is the one about arms. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. 27 words. And those 27 words have generated more legal battles, more political fights, and more Supreme Court cases than almost any other sentence in American history. I'm not going to pretend I can settle that debate in 90 seconds. Nobody can. What I can tell you is that the Supreme Court decided in 2008, in a case called District of Columbia versus Heller, that the Second Amendment protects an individual right to own a firearm for self-defense. Then, in 2022, in a case called Bruin, the court said that any gun regulation has to be consistent with the historical tradition of firearm regulation in America. And right now, in 2026, there are dozens of cases testing what that means. The boundaries are being drawn as we speak. That's all I'll say about that one. The legal framework is evolving in real time, and anyone who tells you it's settled is selling you something. The Third Amendment. This one's my favorite because almost nobody knows it exists. No soldier shall, in time of peace, be quartered in any house without the consent of the owner. That's it. The government can't force you to let soldiers live in your house. When's the last time that came up? Basically never. But here's why it matters. It shows you what the founders were afraid of. They just fought a war against a government that literally moved troops into people's homes. The Third Amendment is a scar, a reminder of what happens when a government treats your private space as its property. And that brings us to the big one, the Fourth Amendment. This is the one that should matter most to you in 2026, and it's the one most people know the least about. Marcus, 29, delivery driver in Columbus, Ohio. He's driving home after a 12-hour shift, gets pulled over for a broken taillight. The officer asks to search his car. Marcus is tired. He says sure. The officer finds his phone on the passenger seat, picks it up, starts scrolling. Marcus doesn't say anything because he doesn't know he can. Here's what Marcus didn't know. In 2014, the Supreme Court ruled unanimously, 9-0, which almost never happens, in a case called Riley v. California, that police cannot search your cell phone without a warrant. 9 justices, all of them. Because your phone isn't just a phone. It's your entire life. Your photos, your messages, your medical searches, your location history, your bank account. A 3-second swipe through your phone reveals more about you than a full search of your house. That's the Fourth Amendment in action. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The founders were thinking about redcoats kicking down doors. In 2026, the door is your lock screen. Quick pause. Let that sink in before we move on. We're about to enter the part of the Bill of Rights that kicks in when the government says you did something wrong. And if you think the first 4 were important, the next group is where the system either protects you or destroys you. The Fifth Amendment. This is where plead the fifth comes from. And I need you to forget everything you've learned about it from TV. Alex, 45, small business owner in Tulsa, Oklahoma. He's accused of tax fraud. The prosecutor wants Alex to hand over his personal financial records and testify about his own transactions. In other words, the government wants Alex to build the government's case against Alex. The Fifth Amendment says no. You cannot be compelled to be a witness against yourself. That's not a loophole. That's not a technicality. That's the entire point. The system says, if you think I committed a crime, prove it. Do your own homework. Don't force me to do it for you. When someone pleads the Fifth, it doesn't mean they're guilty. It means they're exercising a right that exists because the founders knew, from personal experience, that governments love to force confessions out of people. I'm going to be honest. The first time I really understood the Fifth Amendment, I had to sit with it for a minute. It's not intuitive. We're trained by crime dramas to think that silence means guilt. In reality, silence means the government has to work harder. The Fifth Amendment also has something called the Takings Clause, and this one hits close to home. Your neighbor, 52, retired electrician in Tampa, Florida. He's lived in his house for 23 years, paid it off. The city decides to build a highway extension right through his backyard. Can they do that? Yes, they actually can. It's called eminent domain. But, and this is the part that matters, the Fifth Amendment says they have to pay him just compensation. The government can take your property for public use, but it has to pay fair market value. Without that clause, the government could just take your house and say thanks. Now the Sixth Amendment. This is the one about trials. If you're accused of a crime, you have the right to a speedy and public trial by an impartial jury with the assistance of counsel. That last part, the right to a lawyer, didn't fully exist until 1963, when the Supreme Court decided Gideon versus Wainwright. Before that, if you couldn't afford a lawyer, tough luck. A man named Clarence Earl Gideon, charged with breaking into a pool hall in Panama City, Florida, wrote a handwritten petition to the Supreme Court from his prison cell, and won. This part still blows my mind. One handwritten letter from a man in a jail cell changed the legal rights of every single person in America who couldn't afford an attorney. That's the Sixth Amendment doing what it was designed to do. But here's the uncomfortable truth. Maria, 38, teacher in Sacramento, California. She gets a jury duty summons in the mail. She doesn't want to go. She has 32 students, lesson plans, a life. But the Sixth Amendment guarantees the accused the right to a jury of their peers. Maria is the peer. The right that protects you when you're accused depends entirely on people like Maria showing up when they don't want to. 97 out of every 100 federal criminal cases in America never go to trial. They end in plea deals. The jury system only works if there's a credible threat of an actual jury. And that threat only exists if people show up. Stay with me. We're in the home stretch. The next two are quick, but they matter. The Seventh Amendment guarantees the right to a jury trial in civil cases, not criminal civil, where the value in controversy exceeds $20. $20. That number hasn't been adjusted since 1791. In today's money, that's roughly $650. But the principle is the point. If you're in a dispute over property, a contract, a debt, you have the right to a jury, not just a judge. The Eighth Amendment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. 3 protections in one sentence, and every single one of them is being debated right now. What counts as excessive bail? Is $500,000 excessive for a non-violent offense? What counts as cruel and unusual? That phrase has been reinterpreted by every generation since 1791. What was acceptable in 1800 is unconstitutional now. The Eighth Amendment is a living argument, not a fixed answer. Now, the two that almost nobody talks about, and they might be the most important ones. The Ninth Amendment says this: the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. In plain English, just because we listed some rights doesn't mean those are the only rights you have. The founders were worried about exactly this. They were afraid that if they wrote down 10 rights, some future government would say, well, you only have 10 rights and everything else is fair game. The Ninth Amendment is the founders saying, no, this list isn't exhaustive. If we didn't mention it, it's still yours. I'm not going to pretend I found this easy to understand the first time. It's the most abstract amendment in the bunch. But once it clicks, it's everything. The 10th Amendment is the mirror image. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Translation: if the Constitution doesn't say the federal government can do it, the federal government can't do it. That power stays with the states or with you. The 9th protects your unnamed rights. The 10th limits the government's unnamed powers. Together, they're a safety net, a catch-all. The founders saying, we know we can't think of everything, so here's the default rule. When in doubt, the power belongs to the people, not the government. There's a whole rabbit hole here about federalism and state power that I'm not going to drag you into today. Lawyers spend entire careers on just this one amendment. I'm giving you the framework, not the encyclopedia. So here's the picture. 10 amendments, 462 words, and they do something that almost no other document in human history has done. They don't tell you what you're allowed to do. They tell the government what it's not allowed to do to you. That's the inversion. That's the click. Every other power structure in human history started with the assumption that the government has all the power and grants some to the people. The Bill of Rights starts with the opposite assumption. You have the power. The government has to justify taking any of it. Akil Reed Amar, a constitutional scholar at Yale, put it this way. The Bill of Rights is fundamentally about the structure of power between the government and the individual. It's not a gift. It's a restraint. And these aren't dead words on parchment. Right now, in 2026, the Supreme Court is hearing cases about whether geofence warrants violate the Fourth Amendment, about whether the Second Amendment allows concealed carry on private property, about whether the First Amendment protects speech that some states want to regulate. These 10 sentences are being fought over right now in real courtrooms, with real consequences for real people. The structure of the Bill of Rights is, honestly, one of the most elegant pieces of political engineering ever written. 10 sentences that have held up for 235 years through civil war, world wars, the invention of the internet, and the rise of artificial intelligence. That's not normal. That's extraordinary. Now, before I let you go, the 4 mistakes almost everybody makes. First, freedom of speech does not mean freedom from consequences. It means the government can't punish you for speaking. Your employer absolutely can. Second, pleading the fifth doesn't mean you're guilty. It means you're making the government prove its case without your help. Third, the Bill of Rights only applies to government action. A private company can't violate your constitutional rights because the Constitution doesn't apply to private companies. And fourth, these amendments aren't frozen in 1800. They're interpreted, reinterpreted, and fought over by every generation. What cruel and unusual means in 2026 is different from what it meant in 1791. The words stay the same. The meaning evolves. Every state and every fact pattern is different. What you just learned is the framework, not the answer. If you're still here, you now understand the Bill of Rights better than most adults in this country. And that's not an insult to them. It's an indictment of a system that never bothered to teach this stuff in plain language. Here's what I want you to take away. 1. The Bill of Rights is a leash on the government, not a gift to the people. You already had the rights. The amendments just say the government can't take them. 2. These 10 sentences are alive. They're being tested, reread, and fought over in the Supreme Court this term. This isn't history class. This is the operating system running your life right now. 3. If you don't know your rights, it's like having a superpower and never learning how to use it. The power is there. It just doesn't work unless you know it exists. Most people will live their entire lives protected by these 10 sentences and never read a single one of them. That's exactly why I made this video. Not because the law is exciting, although, honestly, parts of it are, but because the system only works if you know it exists. A right you don't know about is a right you can't use, and a right you can't use might as well not exist at all. This is education, not legal advice. If you face a real situation, talk to a licensed attorney in your state. Remember that officer on Route 9? The one who asked for your phone? Now you know the answer. And that answer has been waiting for you for 235 years.